Yes, good morning, Mr. Anderson, Mr. Mackenzie.
Good morning, my lord, my lady. I appear on behalf of the Secretary of State.
You do?
The appellant. Mr. Mackenzie King's counsel appears with Mr. Ferner on behalf of the respondent, who was the claimant below.
Yeah.
I just first to turn to matters of housekeeping, just to check that the court has the documents. We've hopefully got a core bundle,
Yes.
297 pages, supplementary bundle, 150 pages, and an authorities bundle of 360 pages.
Yes.
Now, I apologise that there was an error in the authorities bundle in that I'd inserted the wrong version of the humanitarian protection policy at tab 16.
Well, that passed me by,
Hopefully
Mr. Anderson, but it looks as though you've rectified that because there's another copy on the bench.
By the way, yes, I'm glad to receive that electronically. I've also got copies with hand pagination internally that assists.
I've got it, but the Lord Justice Lewis hasn't got it.
I've got copies I can hand over.
Unless it's already gone in.
And I've paginated these as well, my Lord Justice, in case that assists, because they're not internally paginated in the version I've sent.
Thank you. Got it.
Yeah.
I think we're all. Well, I think we're on top of it now. Thank you. Well, we've read what we think of the key documents, and we've looked at Mr. Justice Chamberlain's decision. So we think we're on top of the issues. Have you had a chance to discuss how long you're going to take, respectively?
My Lord, we haven't had a detailed discussion of that. We certainly don't think that we will detain you for the full day that I think this has been allocated. As we've seen, that there's two grounds of appeal, each of them raise fairly discrete points.
Well, the first point's quite a long point, possibly. Not. The second point's a shorter point.
Yes. The first of those points, or those grounds, being that the court erred in its interpretation of the discretionary leave and medical leave policies, in concluding that historical offending could not be a reason for departing from the normal position of a grant of indefinite leave to remain under the transitional arrangements applying to persons first granted discretionary leave before July 2012. The second ground of appeal concerning the court's grant of relief, which was expressed in terms of the court erring in effectively making a mandatory order that the respondent should be granted indefinite leave to remain rather than simply quashing and remitting. What I was proposing to do, my Lord, is first of all to address you in relation to the discretionary leave policy framework, it being common ground between us that the interpretation of the policy is a matter for this court, then to address you briefly in relation to the facts, then to take you to the judgment of Mrs. Justice Obi in this case, and then address you on ground one, and then after that to consider the matters in connection with ground two, the issue of relief.
That sounds pretty sensible, Mr. Anderson.
So, my Lord, if I can jump straight in then to the discretionary leave policy, which you've got at tab 14, the authorities bundle. It is common ground at the relevant time. It was version 11 of that policy that applied. That's the time of the reconsidered decision in this case. I propose to take you through that in some detail, if I may, beginning at page 245, the authorities bundle, which sets out the purpose of the instruction, explaining that the guidance explains the limited circumstances in which it may be appropriate to grant discretionary leave. It applies in both asylum and non-asylum cases applied from within the UK. It notes that it cannot be applied for from abroad, and it notes that it's intended to cover exceptional and compassionate circumstances, and as such should be used sparingly.
Yes.
Over the page 246, it notes in the second paragraph that transitional arrangements apply to those granted discretionary leave for Article 8 reasons before the 9th of July 2012. And then the policy intention is summarised and reinforced under the section of that heading, noting the policy objectives to maintain a firm but fair and efficient immigration system that generally requires those who do not meet the rules to leave the UK, but carefully considers exceptional and compassionate individual circumstances that may justify leave on a discretionary basis. And then it notes various principles that the guidance is intended to apply, noting it's intended to provide a mechanism to cover those few cases where it would, at the time leave is granted, be unjustifiably harsh to expect someone to leave or enforce their removal. But that will require careful consideration of the evidence relating to exceptional compassionate circumstances, noting that limited leave will normally not be granted for more than 30 months unless there's compelling evidence. And then in the last bullet point, being clear that settlement is a privilege, not an automatic right. It's generally appropriate for migrants wishing to stay in the UK permanently to complete a minimum period of continuous limited leave before being eligible to apply for settlement. Then over the page, there's a section on the application of the policy in respect of children and those with children. I don't propose to take you through that in detail, but you'll see that one of the grounds on which the claim succeeded below was that the Secretary of State failed adequately to consider the best interests of the child in this case, and that finding hasn't been appealed. So I don't propose to say more about
So the consequence of that is what?
The consequence of that is that it's accepted that the decision will need to be reconsidered in any event,
Yes.
even if the Secretary of State is successful in relation to her ground one, as the court observed when it's
Yes.
granted permission. But for that reason, I don't propose to say anything further specifically in relation to the best interests point.
Right.
Then at page 248, there's a section headed relevant legislation, which begins with the uncontroversial point that the Secretary of State has the power to grant leave on a discretionary basis outside the rules from her residual discretion of the Immigration Act 1971, and that discretionary leave is a form of leave to remain that is granted outside the immigration rules in accordance with its policy. And then I note under the heading Immigration Rules, it states Part 9 of the Immigration Rules covers the general grounds for refusal and must be consulted and applied before discretionary leave is granted.
Yes.
Over the page, there's then a section entitled Reasons for Granting Discretionary Leave, which sets out various different bases on which leave might be granted under the current policy. I know that's somewhat different from the historic circumstances in which leave might have been granted because of amendments that were made to the provisions under the immigration rules governing Article 8 ECHR, which would move into Appendix FM of the immigration rules.
But I thought this respondent was initially recognised as having an Article 8 right which prevented removal,
My Lord,
and that's why he had discretionary leave.
My Lord, that's right. And his application is made on the basis of his having been a person with granted discretionary leave before that change in the rules took place, which is why it's been made under this policy rather than being made as an application for leave to remain on Article 8 grounds under the rules. Of relevance in this case in particular, on page 249, under the heading medical cases.
So he couldn't qualify under the rules for indefinite leave to remain on Article 8 grounds at the moment.
My Lord, he certainly hasn't made an application to be considered on that basis. But you'll see under the heading medical cases, under the third paragraph, it says when considering medical claims, you must follow the guidance on medical claims under Articles 3 and 8 of the European Convention on Human Rights, which is one of the two sets of policy guidance that's relevant to this claim that the judge below considered. So I'll take you to that in due course. Moving on within the policy, at page 254, there's a section that's headed Exclusion and Criminality. It begins by saying that in all asylum and non-asylum cases, you must consider the impact of an individual's criminal history before granting any leave. And then a paragraph that says whether reasonable grounds for considering the claimant should be excluded from asylum or humanitarian protection, you must refer to the guidance on exclusion. I pause there just to note that this isn't an asylum or humanitarian protection case. So this isn't a case which the exclusion guidance is directly relevant. And then over the page 255, there's a paragraph, a third paragraph on that page, where an individual does not fall within the restricted leave policy, for example, where they're not excluded under Article 1F of criminal sentence of less than 12 months imprisonment, you must consider the impact of any criminal history before granting discretionary leave, having regard as appropriate to Part 9, brackets, general grounds for refusal. And the last sentence of that paragraph, criminals or extremists do not normally benefit from leave on a discretionary basis under this policy, because it is a Home Office priority to remove them from the UK. I just pause to note that the reference to Part 9 there is the same Part 9 that was referred to in the section of this policy dealing with relevant legislation. Then the next passage that appeared relevant to this case is at page 264.
255 must be relevant too, the next paragraph, because this is somebody, A, who was granted discretionary leave, and B, you granted him discretionary leave again. So you must have thought, even if you didn't get indefinite leave, you must have thought that he should be granted discretionary leave even though he had a criminal history.
My lord, yes, that's right. And I'll take you in due course to the transitional provisions section that applied in his case because of in fact, his initial grant before July 2012.
But you must have considered at least 2 or 3 times that there are exceptional reasons for granting discretionary leave, notwithstanding the criminal offending.
My lord, yes. My lord, I think the next section of the policy that appeared to me to be relevant is the section headed further leave applications, which is page 264. And just to note the first paragraph of that section, which says, this section applies to those granted in the initial period of discretionary leave on or after the 9th of July 2012. For cases where discretionary leave was granted before 9th of July 2012, see transitional transitional
Provisions. Arrangements, yes.
I'm so sorry, it's my fault, Mr. Ransom. Where have you got to? Because I'm just writing a note and I.
264.
Sorry,
264.
it's 264.
That's my fault. Sorry.
First sentence, 264.
Right, thank you.
Yes.
So,
Transitional arrangements. So, what do you want? Do you want to say anything about what's here, or not?
my lord, no. Just to flag that because this is there is a section that deals with, as it were, current situation in relation to those who hadn't been granted their initial period.
Do we need to know about that at all?
My lord, not in detail, but I think it may be helpful to look over the page 266. There's a section called Further Leave Applications, General Grounds for Refusal, brackets, Criminality. And you'll see that explains in the first paragraph that on the 1st of December 2020, the immigration rules were amended to introduce a single threshold for mandatory refusal on the basis of a custodial sentence of at least 12 months. It says the new criminality rules apply to applications made after 9 AM on the 1st of December 2020. And since we've got it quoted here, we can see what that says. An application for entry clearance, permission to enter, or permission to stay must be refused where the applicant has, amongst other things, been convicted of a criminal offence in the UK or overseas for which they've received a custodial sentence of 12 months.
So this tightened it up, did it? Is that the effect of it?
My lord, yes.
Did you say it's relevant to the relevant to the exercise of discretion in this case that it was tightened up?
My lord, yes.
Thank you.
Can I just check? This is concerning the further grant of discretionary leave. And were this to be a current policy case, he would not get discretionary leave at all because he's got a criminal offence with a sentence of 30 months. Is that what the position would have been
Well,
for discretionary leave?
well, my lord, it's a little more nuanced than that. If you look further on page 266,
Yeah.
you'll see under the heading considering further discretionary leave, it says there's a cohort of claims
Yes.
where a claimant has a previous custodial sentence of 12 months or more that has previously been granted discretionary leave went on to the sentence and is now applying for a further grant of discretionary leave. It then says under part 9 of the immigration rules, this application must be refused. However, for this cohort, an exception may be made if certain criteria apply. And I should note this is separate from the transitional provision.
I understand
that
that,
I'll
yes.
take you to. But it then says you may grant a further period of discretion to a claimant if all the following criteria apply. Claimants previously been granted discretionary leave. The circumstances prevailing at the time of the original grant continue to apply. The offending occurred before the previous grant of discretionary leave, which means they were last granted discretionary leave in the full knowledge of their previous convictions. They've not received any subsequent convictions, and they don't fall within the scope of the restricted leave policy.
So that means you can get 30 months discretionary leave. What would happen if somebody came along and wanted not just discretionary leave, and this is post-transition now, and wanted not just discretionary leave but settlement?
Well,
Indefinite leave to remain.
my lord, there are two passages that are relevant to that. So over the page,
Yeah.
page 267, you'll see that under the heading considering settlement,
Yeah.
it says settlement is a privilege and not an automatic right. This is a long-standing position. Being granted leave in a particular route with no expectation of anything further other than granted. Therefore, further discretionary leave can be granted when the above criteria applies. However, any indefinite leave to remain application is also considered by reference to the immigration rules appointing the application, unless there are exceptional mitigating circumstances that would otherwise warrant a grant of leave. We must continue to consider applications for settlement on a case-by-case basis, applying the current general grounds for refusal and policy.
So does that mean that if you applied now under the current policy and you had previous offending, you would be eligible for discretionary leave, but you wouldn't be eligible for indefinite leave to remain unless you satisfied the immigration rules? But in fact, you would never satisfy the immigration rules because of your previous 12-month sentence.
Or, my lord, potentially if there were exceptional mitigating
Or
circumstances.
exceptional mitigating circumstances. But the current position is you shouldn't get discretionary leave at all if you've got a 12 months plus sentence. If you've already had discretionary leave, you can get more discretionary leave if there's been no change, but you wouldn't get indefinite leave to remain because of the criminal sentence unless there are exceptional mitigating circumstances. Is that correct?
My lord, yes, that's my understanding of how that fits together.
All this is relevant, you say. All these provisions are relevant to the exercise of discretion in this case, we're coming to it with the transitional provisions in a moment.
My lord, yes, I propose to show you exactly how, but I think it's helpful in terms of understanding the transitional provisions
It
and
is.
the differences it may make compared to the current policy to have an idea of what the current policy says and how it might apply. and you then go over the page under the heading Settlement Applications, page 268.
Yeah.
Yeah.
And you'll see, again, just in terms of the header here, it says this section applies to those granted an initial period of limited leave under this policy on or after the 19th of July 2012. We don't fall in the restricted leave policy, and it again refers to the transitional arrangements where the initial period of discretionary leave was granted before the 9th of July 2012. Provides an individual will normally be eligible to apply for settlement after completing effectively 10 years residence. But then under the heading granting settlement, you'll see it says where an individual is held discretionary for a continuous period of 10 years and continues to qualify for discretionary leave under the policy, they should be granted settlement unless there are any criminality or exclusion issues. And then there's a hyperlink on criminality
Back to
or
that.
exclusion, which takes you back to the exclusion and criminality section, page 254.
And that's the one that says if it's 12-month sentence or more, you can't get it.
That's what, yes, refers back to part
Part 9.
9, general refusal. And then finally within this document we have the transitional arrangements themselves. Under the heading Applicants granted discretionary leave before the 9th of July 2012 on page 271, it says those granted leave under the discretionary leave policy in force before the 9th of July 2012 will normally continue to be dealt with under that policy through to settlement if they continue to qualify for further leave on the same basis as their original discretionary leave was granted. And then it says in brackets, normally they will be eligible to apply for settlement after accruing 6 years continuous discretionary leave, or where appropriate combination of discretionary leave and leave outside the rules, unless the date of decision they fall within the restricted leave policy. It then says, in the next paragraph, you must consider whether the circumstances prevailing at the time of the original grant of leave continue at the date of decision. If the circumstances remain the same, comma, the individual does not fall within the restricted leave policy, and the criminality thresholds do not apply, a further period of 3 years discretionary leave should normally be granted. You must consider whether there are any circumstances that may warrant departure from the standard period of leave. Now, I just pause to note there that the reference to criminality thresholds isn't further defined, and there may be a potential ambiguity as to whether that applies to the criminality thresholds in this policy, that is the current policy, or to criminality thresholds in the policy before 9th of July 2012. But that's, in my submission, clarified. One reads on. It says, if there have been significant changes that mean the applicant no longer qualifies for leave under the discretionary leave policy, or the applicant falls for refusal on the basis of criminality, brackets the exclusion criminality section above, the further leave application should be refused. And again, that hyperlink takes you back to the section.
Yes. Can I ask you about the interpretation of that sentence? Does the phrase, if there have been significant changes, qualify only the next bit, that mean the applicant no longer qualifies for leave under the DL policy, or also the next bit, or the applicant falls for refusal on the basis of criminality. In other words, could one exclude the middle bit and read it, if there have been significant changes that mean the applicant falls for refusal on the basis of criminality?
In my submission, my lord, no. What the first part of that sentence is getting at is that there may have been changes in the circumstances that led to the grant of discretionary leave in the first place. So, for example, in this case, suppose the respondent suffers from a chronic condition that isn't curable. Suppose instead the respondent had suffered from a condition that was curable, or that hadn't been curable but the cure had been devised. In that circumstance, then it may be that there would be no need for grant of discretionary leave at all, on the basis that, say, their health was no longer a compassionate circumstance as to why they should be granted leave at all. That's what that first part of that paragraph is getting at. So it's changes.
Why do you say that the phrase "if there have been significant changes" does not qualify the next bit, and only the first bit?
Because, my lord, of that, for two reasons, my lord. First of all, because that's consistent in my submission with the fact that one of the things that you look at when you're considering whether to grant further discretionary leave is whether the circumstances are the same. A second thing you look at is criminality, and I think that's reflected in the or there as well.
I'm having some difficulty in understanding at a very basic level how this operates. This is the position for people who have been granted discretionary leave before the 9th of July 2012. Such people, including this respondent, would and had been granted discretionary leave before the 9th of July 2012, notwithstanding the fact they had a 30-month sentence or 13 offences applying factor case. So I don't understand what the criminality thresholds mean in this context, because they didn't mean he couldn't get discretionary leave before the 9th of July 2012 when he got it. If the same policy is being applied when he renews it, I don't see at the moment what that middle paragraph means, what the criminality thresholds mean, unless it's a new crime rather than the old crime, if you follow me. Otherwise, if it's the old crime, I can't make it work, if you follow my problem.
My lord, I think I do, and in my submission, the answer to that may ultimately be a difference. Well, there's perhaps 2 points to it. But the first, if we can just read on to the next paragraph, because I think it just helps in terms of having that section hold. There's a further paragraph in relation to those who've been granted discretionary leave for shorter periods of time. But I think the answer to your question may lie in the distinction between the grant of discretionary leave for a limited period and settlement, which has been characterised in the policy as being a privilege rather than a right. And so there may be circumstances in which the Secretary of State may consider that, notwithstanding an individual's criminality, it remains appropriate to grant them a further period of discretion, but not necessarily to grant them the privilege of
I understand
settlement.
that, but before you get there, assuming it's not somebody who wants discretionary leave, assuming it's somebody who wanted a further period of discretionary leave, according to the second paragraph, a further period of 3 years discretionary leave should not normally be granted. That is, should not normally be granted having regard to the criminality thresholds. But it's been granted before and it's supposed to be the same policy. So why isn't he having discretionary leave, forget settlement for a moment, because of a 30-month sentence, when under the policy as it previously applied, he would be getting discretionary leave, notwithstanding the 30-month sentence? That's my first problem.
My lord, that in my submission is because the policy at the outset notes amongst the relevant legislative provisions for the purposes of this policy as a whole is Part 9 of the immigration rules. this section in relation to the transitional arrangements makes reference to the exclusion and criminality policy within the body of the current policy in the hyperlink in the penultimate paragraph. And so you've got to try and as it were, read all of it together. And in my submission, reading all of it together, including the reference to exclusions and criminality policy, means reading the previous policy but subject to what the exclusions and criminality section of this policy says.
Could it mean, or could the reference to criminality thresholds, which is not exclusion and criminality, could that, in the context of further grants, be a reference back to page 266 and the circumstances where, notwithstanding previous criminal conviction, you can still get a further grant, i.e. there's been no offending in the offending, no further offending in the offending was before the DL. Could that be what it meant? It's continuing the regime, and unless there's been no further offending, you'll be able to get the new offending because the criminality thresholds will have been passed if they're the 266 thresholds.
Well, my lord, those may well be amongst the circumstances in which a person may be granted leave, notwithstanding meeting the criminality thresholds. Yes, I should note that the hyperlink itself takes you to 254.
Yes.
But that's the hyperlink for exclusion and criminality, is it?
266.
But I'm talking about the second paragraph, which firstly doesn't use the words exclusion and criminality, secondly doesn't have a hyperlink, thirdly refers to criminality thresholds, and fourthly is in the context of continuing leave that you've already had before, and when you had it at a time when you had criminal offending. And that makes me think that that paragraph must mean that you can still get further discretionary leave, notwithstanding criminal offending. And the only way to make sense of it is to say there's a reference back to 266. If it's the old offending, you can still get discretionary leave. That doesn't affect your case on ILR, but I'm just wondering what that paragraph means. But do you see where I'm coming from?
My lord, yes, I do. And as I indicated, criminality thresholds in that paragraph isn't a term that's defined elsewhere.
What do you say it means?
Well, I think reading it as a whole, that is reading the third paragraph as well as the second paragraph, and that reference back to 254, I think it's intended to encompass in terms of the threshold, if we consider the threshold as being the level of offending or the seriousness of offending, to the levels or seriousness of offending that are set out in paragraph 9.4.
I understand that, but it wouldn't make sense if you just applied that paragraph. You would be applying the earlier transitional policy. That's why I wonder whether paragraphs 2 and 3, 2 is referring to a continued exception where you've got previous offending which occurred before the original grant of DLR, and the next paragraph must have been intended to refer to new offending.
Well, in my submission for the reason that I sought to submit earlier, that next paragraph, that's the third paragraph, the reference to changes is intended to qualify the first part rather than necessarily.
No, I understand that, and that's not the reason why I'm saying it might be looking at new offending. What I'm saying is you've got to read, the context is you're carrying on under the old policy,
Yes.
and you got it under the old policy even though you've got a 30-month sentence. There's that middle bit which talks about it carrying on subject to the criminality thresholds, which is different from exclusion from criminality. So it may be that so long as it's something that's happened beforehand, you can get it. And then the only way you can make any sense of 3 in context, and bearing in mind paragraph 2, is when they were talking about exclusion and criminality sections, they were talking about new offending, which cross the threshold. Otherwise, it doesn't seem to make sense. It's not clear what's happening otherwise.
My lord, in my submission, what it is intended to do in terms of that, as I say, together in my submission, would be to indicate that the offending, if it's above the level of the only thresholds we have within the policy in terms of levels are those set out in Part 9. Maybe circumstances in which the Secretary of State will have to have regard to that criminality in considering whether to grant further leave under the policy. But obviously the fact that the Secretary of State has previously granted discretionary leave in the knowledge of that offending is going to be relevant to that. So when we come to the...
But it's worse than that. That further leave should be refused. If you're right, and you read all of it together, you can't even under the old policy, because it's actually been changed, get a further grant of leave if even there was old offending above the threshold, because that's what the third paragraph says. So if you're trying to carry on the old policy, and if you've got a bit talking about something different, criminal thresholds, although it's as clear as mud, maybe the position is old offending, you don't stop the grant of leave. New offending, if it's above the threshold, you don't give discretionary leave. So if you've got an old offending of 30 months, you've got a 6-month sentence for dangerous driving, not above the threshold, you'll be all right. The old offending is dealt with by the second paragraph, the new offending is dealt with by the third paragraph. It's only a suggestion of trying to make sense on discretionary leave grounds about what this is about. Otherwise, you're not applying the old policy, you're applying a new policy.
I mean, my lord, I accept that it's not as easy to construe as it might be. And the reading that your lordship proposes is
I think we're with you on that one, Mr. Anderson.
certainly a possible reading of how the policy would fit together. But it, as I say, in my submission, for the reasons I previously sought to advance before the court, what it's really doing is making clear that even in the context of a grant of discretionary leave, the Secretary of State must have regard, at least, to the thresholds in Part 9. Because exclusion and criminality is a matter which will always fall to be considered.
Can I approach the question well, from the same question from a slightly different angle, or possibly the same angle? Forgive me if it is. I think I'm not clear what your submission is about the meaning of custody of criminality threshold. It has to have a meaning. What is it?
My lord, in my submission, the best way to understand it, because it's not a term that's expressly defined, and criminality threshold implies as it were, a level of criminality that somebody must reach. The threshold that is referred to in the policy is the Rule 9.4.1 threshold. That is circumstances where somebody's been convicted of a criminal offence, grossly received a custodial sentence of 12 months.
Why didn't they put exclusion and criminality with a hyperlink in the second paragraph where they put criminality threshold? Surely they must have meant something different.
Well,
There's one way to read this controversial paragraph to say that what the draftsman must have intended is living significant changes, blah blah blah, leave under the DL policy, and/or the applicant falls for refusal. In other words, it's focusing on things that have happened since. The focus of that bit is things that have happened since the last grant of leave, both in respect of significant changes that mean the person able to qualify for DL, and in respect of a new crime that meets that means that the exclusion criminality bit applies to the new crime, but not to the old stuff.
That's the third paragraph.
Yeah.
Yes.
That would achieve the same result.
Yeah.
I mean that's.
Because this, after all, is a policy, not a statute.
Yeah.
And it seems to me the way to make sense of it might be to go, as I say, to go and / all.
the other way of reading the two paragraphs together may be to consider that the third paragraph is, in a sense, describing the negative of the second paragraph. So the second paragraph, in setting out what the decision maker must positively consider to be satisfied whether they should grant discretionary leave, says you must consider whether the circumstances prevailing at the time of the original grant of leave continue at the date of the decision. If the circumstances remain the same, they don't fall within restricted leave, and criminality thresholds don't apply, a further period should normally be granted. I just underscore the normally there as well, of course. It's not saying necessarily that
We're going to come on to
circumstances.
normally, I think.
It's normally, not
Yeah.
a rule. But the next paragraph, you could essentially read as being the inverse of that. If there have been significant changes that mean they no longer qualify, or if they fall for refusal on the basis of criminality, then the application should be refused. Effectively, it's the mirror image in that
Okay.
sense of the.
What is the can you give an example of somebody who would, to whom the criminality thresholds do apply, but they don't fall for refusal on the basis of criminality? Because, can you give an example of somebody who would, you see, in other words, I'm trying to find someone who would fall within one but not the other. So it's someone for whom the criminality thresholds do apply, but does not fall for refusal on the basis of criminality.
Well, my lord, that's where the Secretary of State's discretion comes into it.
Yes.
We've got there are circumstances that are potentially outlined earlier in the policy at page 266. There may be other circumstances, for example, if there are particularly exceptional or compelling considerations. Such as an individual might be granted leave effectively, notwithstanding their criminality, effectively on the ground that their circumstances were particularly compelling or compassionate for
Yes.
whatever reason.
That all may be right, but I'm just trying to think of somebody in respect of whom the criminality thresholds do apply, so they don't fall within this paragraph 2, but nonetheless falls for refusal on the basis of criminality. See what I mean? Can you think of somebody who falls, the thresholds do apply, but nonetheless does not fall for refusal on the basis of criminality? Am I making myself clear?
My lord, not unless it were considered that there were particular. If one was simply applying the new policy, then one would be looking either to the circumstances that are set out at page 266, or to the question whether or not there are exceptional circumstances or grounds falling outside that.
They must be intended to be different people, mustn't they? Because under the third paragraph, leave should be refused. So if you fall for refusal on the basis of criminality, it's got to be refused. But in the second paragraph, they should normally granted leave. So
Well,
what's the difference?
under the second paragraph, my lord, they should normally be granted leave where the criminality thresholds don't apply. And that's why I say you could read the third one as being, in a sense, the inverse of the second one.
I'm not trying to understand that. Just stepping back, and forget the words for a moment. The pre-2012 person who had offended once and been granted discretionary leave would, under the old policy, as I understand it, get a second discretionary leave unless the circumstances had changed or there was new offending. That's what the old policy was, as I understand it. Is that right?
My lord, yes, it may help in due course if we go to the old.
Yeah, but assume that's right. The new policy, as it happens, says something quite the same. It says, oh, it's terrible, if you've done a crime, you can't get it, brackets, unless it was the same one as you've already done before, and then you fall within the exceptional circumstances. So I don't see how 271 can be intended to bring about a situation where somebody who's been granted one discretionary period of leave after offending, the circumstances have not changed, there has been no further offending. If he's refused discretionary leave, he's worse off than under the old policy, and worse off than under the new policy. And surely even the Secretary of State didn't intend to do that, did she?
Well, my
Or
lord,
he?
that's obviously not. I mean, that's obviously, my lord, not what happened here. We're dealing with a case
Look,
where
we've got to get to the position of discretionary leave in order to see whether the words for the indefinite leave apply. And the key thing here is whether this is really aimed only at new criminality or whether it includes existing criminality, and that may or may not be relevant to indefinite leave. That's why it's important to understand what you say the position is for somebody pre-2012 who had had one period of discretionary leave following a conviction and applied for a second period of discretionary leave with the same circumstances and no further offending.
my lord, in that situation, normally that person will seek further grant of discretionary leave.
Yeah.
And I do emphasise the normally because it's not an absolute, but that is normally what would happen.
Okay, I'm not sure where any, for my part, I'm any clear as to how those two paragraphs interrelate. But I may be none the wiser, but I'm better for. Before you say it.
If I can think of a more elegant way to try to put it, my lord, then obviously I will.
That was pretty elegant.
I will do so.
Anthony Smith goes to still haunts this building. But anyway, so we may come back to that because it may be the crucial part of the case. But unless you want to say anything else about it, those two paragraphs, should we go on?
My lord, only just briefly to note one point which I don't think I've expressed majorly, but it was a point that was picked up in the skeleton and also picked up in the grant of permission, and that is simply the use in the in that section of the two normalies. That is to say, normally we don't under the old policy, and normally that will mean because of the further period of leave. And I'll pick up this point in due course when we look at Ellis, but in my submission, Mr. Justice Chamberlain was right to say, as he did, that the use of normally was intended to preserve significant discretion of the Secretary of State.
Yeah. Right.
My Lord, now if we turn to the pre-July 2012 policy itself, which is in the next tab 15. And I don't think I need to take you to those sections that describe the purpose of the policy, the various categories of present purposes. But if we can look at page 280, there's a section headed Applicants Excluded from Refugee Status, Humanitarian Protection or Discretionary Leave. And the third section there, Exclusion from Discretionary Leave, says that the grounds for exclusion from humanitarian protection will apply to discretionary leave. See the asylum instruction on humanitarian protection for the relevant grounds. A person who's excluded from discretionary leave will be expected to leave the UK where neither enforced nor voluntary return is possible without material prejudice to the rights protected under this instruction. Discretionary leave will usually be granted for 6 months. And I'll take you in due course to the humanitarian protection policy itself. Then at page 287, there's a section, Applications for Further Leave, which says that a person will not become eligible for consideration for settlement until they've completed 6 years of discretionary leave, or in the case of persons subject to exclusion criteria, until they've completed at least 10 years of discretionary leave. Anyone granted discretionary leave will therefore have to have at least one active review before they're eligible for consideration for settlement. So the old policy drew a distinction between individuals who were not subject to the exclusion criteria who were on a 6-year route, and individuals who were subject to the exclusion criteria who were on 10-year route.
Yes.
And then there's over the page 288 under applications for settlement. The same point is essentially made in the first paragraph.
Before we get to settlement, is there anything about when an application for further discretionary leave should be refused or granted, which might help us understand the background against which the difficult paragraph that we've been looking at was dealt with? Can I find out from this anyway whether if this is my second application for 3 years discretionary leave and I've not committed any further criminal offences, I would or would not normally get the second discretionary leave, or do I not know?
My lord, I don't think that there's anything that's expressly set out under that section, applications for further leave, that sets that out.
Does this previous policy have a section on exclusion and criminality, for example?
It has only that section that I took you to before, applicant excluded from refugee status, humanitarian protection, or discretionary leave, at page 280.
Right.
So the previous policy was silent on the second grant of discretionary leave in cases of historic offending. Is that what you're saying?
My lord, I can't see that there's something in the policy that expressly
It was
addresses that.
focused very much on the length of time, wasn't it? The passage of time.
My lord,
6 or 10 years, depending on the circumstances. Is that right?
My lord, yes, and you will see. I don't think it necessarily sheds light, but on page 286, there is a section on curtailment of variation for the leave or
Right.
character of conduct, which makes provision for circumstances in which there's been a person who has been granted leave then comes to satisfy the exclusion criteria as a consequence of conduct.
As he does the
which may be
crime
reasonable.
after the grant of the leave.
Yes,
Yeah.
but
So-
that's concerned rather with curtailment than with the question of a further
But
application.
there are provisions about criminality in the humanitarian protection provisions, are there?
My lord,
Just
I'll take you to it, but
anticipating that.
It's simply yes, and that's simply effectively that's used to set out the threshold at which the exclusion under
I
the
follow.
old policy.
So nothing express, but by reference to that humanitarian protection policy, which we'll come into in a minute. Thank you.
So, and it may partly be that the way that the applications for further leave policy is or the page dealing with application for further leave at page 287.
Yeah.
It may be that it doesn't refer expressly to the issue of criminality because it makes instead broad reference to deciding whether or not the person still qualifies for discretionary leave.
That's looking at the reasons why he had to have it. The incurable medical condition, the family. He didn't qualify for it because he committed a crime. The committing the crime might have been something that disqualified him, but we know it didn't. So that can't be looking at the crime. That must be looking at the reasons why he wasn't removed but was allowed to stay.
My lord, the reason that I submit that it may be broader than that is simply that otherwise there wouldn't be any, in relation to a second application, if I can put it like that, there wouldn't be any provision dealing with the issue of criminality at all.
That's a bizarre thing.
But in my submission, the answer to that may be that if the question whether or not somebody qualifies for discretionary leave if they're excluded.
So if he was convicted a second time and then applied for a second leave, the still qualifies could cover that. Okay.
My lord,
But
yes.
it wouldn't cover the first one because it's talking about still qualifies, and he did qualify with the first offending. So the still qualifies could again only be relevant to fresh offending before the application for the second period of discretionary leave. That must be right, mustn't it?
My lord, it's only fair to say that it doesn't. I can't take you to anything else in the policy.
Well,
on that, other than-
So the scheme is that anyone granted DL has to have at least one active review before they become eligible for settlement. So the rather than spelling out the effect of criminality, that there will be an opportunity for the Secretary of State to have considered criminality at the active review, and the opportunity to curtail the grant of leave in circumstances that are undefined but would include criminality. There's no, as it were, hard-edged threshold or provision in this policy,
The threshold, my lord, I'll take you to, which is set out in the
subject to the
humanitarian
humanitarian. Okay, fine.
policy.
Right. Okay.
But
What
yes,
else do
that's
we need
right.
from this
The
document?
possibility of curtailment or
Yeah.
the active review consideration. The last in this document is really page 288 under the heading applications for
Yeah.
settlement.
Yes. We looked at this, didn't we?
And effectively, it reiterates the first paragraph that the person will normally become eligible for settlement after completing 6 continuous years. But where they're covered by one of the exclusion categories, they won't become eligible for consideration until they've completed 10 continuous years. And then
Consideration of application shows the process. There's another active review. It's the same scheme, a series of reviews rather than.
yes, and
Yes.
it's different insofar as this provides that where somebody's subject to this expression provides where somebody's subject to exclusion criteria, they're still only route to settlement, but it's a longer route, it's 10 years rather than 6 years. Subject, you'll see under the heading personal decision by ministers, to the fact that where a person who's subject to grounds of exclusion has completed 10 years of discretionary leave, they may still be denied settlement where ministers decide in light of all the circumstances of the case, the person's presence in the UK is not conducive to the public good, and it says that may be decided in individual circumstances of the case or for a category of cases.
Can I just say, so I read the first paragraph and I say to myself, right, normally it's 6 years. The departure from that is when it's 10 years for the exclusion cases. That's what normally is qualifying then. It's qualifying the period of time. Is it 6 or 10? I say, right, done that. I move to the next paragraph. Do they still qualify? Well, yes, I got it for medical reasons. I've still got those medical reasons. True it is I had an historic offending, but that didn't disqualify me then. So I qualified then, and I must still qualify now, and there's no further offending. So I tick that box. Then I get to 3, granting settlement. Where a person has held discretionary leave for an appropriate period and continues to qualify for discretionary leave, sigh of relief, I do, because I've still got the medical condition and nothing has happened to make me stop qualifying, I should be granted ILR. That seems to be saying that if there's nothing new and the old reasons for qualifying hold good, you should get ILR. There's nothing, it's just to qualify that.
My lord, under the old policy, yes, that's right, subject to the possibility of the personal decision by ministers.
Yes, which is in this case, yes.
In this case, but if one was simply looking at the old policy,
Yeah.
then that
You would
that
get
I think
it
is-
automatically.
That I think is
And any historic criminality could not be taken into account at that point. Is that right?
it
Under
would,
the old policy.
it would be relevant to the period of time an individual had to accrue.
Yes.
Yeah, but
rather
not.
than standing as
But provided he did the relevant period of time, it wouldn't be relevant for any other purpose.
if one was simply looking at the old policy.
Yeah. Right. And I thought the position was that for pre-9 July 2012 people, you are looking at the old policy.
Well, the transitional provisions under the new policy or the current policy, version 11 that we looked at, say that normally you'll be dealt with under that.
So it's not quite the same. They have qualified it then.
It's qualified in that respect, and it's qualified in my submission because of the various references I took you to in looking at that new policy, to the reference, for example, to Part 9 of the immigration rules. And so what we've got, what in a sense the court's task is to make sense of all of that, so that all of it speaks. And the nub of my submission is that the Secretary of State's approach in this case managed to do that effectively by granting, in circumstances where Part 9 would ordinarily provide an individual shouldn't be granted discretionary leave at all, granting a period of limited leave rather than granting settlement. My lords, I told you I would take. Oh, sorry.
Just so we're clear, do you want to take humanitarian protections? Do you?
I was just briefly going to take you to the humanitarian.
But just so we take stock of where we've got. Under the old policy, we're agreed, are we, that historic criminality would not preclude, would be irrelevant to the question of whether or not someone should be granted discretionary leave, granted settlement at this point under 288.
My lord, with the caveat, and I think it is an important caveat, but with the caveat that the rule of law, as it were, at issue is that the Secretary of State must follow her published policies unless there's a good reason not to.
Yeah.
There may be circumstances that would fall outside the four corners of the policy.
Yeah.
But yes,
Ordinarily
ordinarily,
wouldn't normally. If you had a child killer that had killed 6 children across the north of Yorkshire, the public repulsion may be so great, you'd say, I'm sorry, under no circumstances, honey child, you ain't staying here. So there would be circumstances, but as a generality, historic offending would not be a bar to the grant of settlement.
that's right.
And you'll have to, it's my fault, you'll have to persuade me again that the transitional arrangements were intended to qualify that and to introduce a bar whereby historic criminality could now be something that fell within the normally exception. But that's my own fault for not having fully understood it.
No,
The reason why I just wanted to be clear about that, because that does concern me as well. And can I just ask this question? This is quite a major change, isn't it? In other words, when historic criminality would not be taken into account, save in the exceptional circumstances, it's now is going to be taken into account in the discretion of the Secretary of State. One might, can I make this observation? One might have expected such a significant change to be clear from the language of those two paragraphs, as opposed to what seems to be, frankly, unclear, as I think we've already demonstrated.
well, my lord, I take that point, and in my submission, the response to that is, or the key points that I invite the court to take from the new policy, which in my submission changed the position, are first of all the reference in the transitional arrangements to the two normalities. That is, so if we go back, perhaps just before we do go back to it, if I just to complete the picture, I should perhaps just take you to that reference in humanitarian protection.
Yes, I don't want to take you off track, so you can see what's troubling the Lord and myself. Yes.
Now, my apologies, as I say, I gave you the wrong version in the authorities bundle.
So I think we're going to just lose the first version, which is the one which was here.
And I think I handed up earlier the paginated.
You did?
You
got it? Paginated?
And you will have seen that the pre-July 2012 policy referred to the exclusion criteria under the humanitarian
Yes.
policy. Those are page 12. And of most relevance, probably to the present circumstances, are the reference to a serious crime. So under the exclusion criteria number 1, there are a series of reasons for considering the individuals committed various sorts of crime, including a serious crime. And then serious crime is defined about halfway down the page as one for which a custodial sentence of at least 12 months has been imposed in the United Kingdom or various other circumstances.
So that would mean you wouldn't qualify for humanitarian protection.
Yes.
And just remind me how that feeds into discretionary leave and ILR again. I know you've told us, but
My
short-term memory's gone.
No, my lord, it feeds in because under the old policy,
Yeah.
the section that was headed applicants excluded from refugee status on page 280.
Yeah.
You've got a section applicants excluded from refugee status, humanitarian protection for discretionary leave. And then a third of those categories, it says the grounds for exclusion from humanitarian protection will apply to discretionary leave.
So what does that actually mean? Does that mean that if you've got a conviction for 12 months or more, you don't get discretionary leave?
My lord, yes, that's what that appears to be subject, and you'll see that that's subject to the possibility that it notes that if return isn't possible without material prejudice to the rights protected under the instruction, discretionary leave will usually be granted for 6 months. Now, my lord, there is here, of course, a sort of perhaps a factual curiosity, of course, because of course in this case the applicant was granted discretionary leave for periods greater than that of succession.
Under what? Under Article 8. Right. Okay.
So that would be, you wouldn't get it at all. But what happens if you've been granted it once and you've decided either to do 6 months because you can't enforce or have a voluntary leave, or if you say this is Article 8 and it's not covered by the word and I'm going to give 30 months, so you weren't actually applying page 280 at all. What happens the next time you come round? Do you go through the same route again? You say, well, I'm sorry, you've still got the 12-month sentence. You can't get any further discretionary leave unless return is still not possible. Or do you still do Article 8 and get 30 months?
Well, my lord, I think, and of course it's an old and not a current policy, I think the intention of that passage appears to have been to provide for a shorter grant of leave in circumstances where enforced or voluntary return isn't possible at the time. And the purpose of that is presumably that circumstances may change and effectively you're keeping it under a tighter.
Yes, just in case there's, yeah.
Okay. So answering my lord's point, do we go back to the applications for further leave to see what happened in this case?
My lord, yes.
And there were further reviews, a series of reviews, were there?
Well, in this case, my lord, yes, there were a series of grants of discretionary leave to remain. I think the original grant was on the 17th of February. Sorry, the original grant was on the 10th of August 2010, and then there was a series of subsequent acts, which was for a period of 3 years. That followed a decision of the first-tier tribunal, effectively allowing an appeal against the refusal to revoke a deportation order. And then there were subsequent grants of 3 years discretionary leave on the 12th of December 2013, 2nd of October 2017, and the 26th of May 2021.
Can we just take the first extension then and just fit that to the words of 287? So we know he's got it now. We know that he shouldn't have got it normally because he's got a 12-month sentence. It's a serious crime. He should only have got 6 months and it should have been checked. But for whatever reason, he got Article 8 and he got 30 months. But he's coming up again now for an extension. And it's his extension request will normally be the subject of an active review to decide whether the person still qualifies for discretionary leave. Now, one argument could have been, well, no, he doesn't qualify for discretionary leave. he still doesn't qualify for it because of the 12-month original sentence. But that isn't what happened. They regarded him as still getting discretionary leave and therefore presumably still qualified for it. So they can't have regarded the provisions governing the initial exclusion as being relevant to a renewal or extension, can they?
My lord, I don't know that I can necessarily go behind or further explain the decision making at that time beyond noting that he was granted a further period of 3 years, having originally been granted a period of 3 years. Yes.
Right. So it wasn't limited to the 6 months. And if you take the words on the page, it must have been because they thought he still qualified for discretionary leave, notwithstanding the earlier offence.
So, my lord, that was the suite of policies, as it were. And in terms of returning
To my
if we could just turn up Ellis.
But you're going to go back to explain how it was that this worked into the normal leave. Remember?
yes, that's right.
Yes.
Before we went to normally, you asked to go back. You asked to go to the humanitarian protection. So we go back to
Yes.
the current document, and we now look at the normalies.
Which page are we on?
It's 271.
Oh yes, how could I forget it? Yes.
It's covered in red ink in my copy. So one normally is there in the second paragraph. Where's the first normally?
So we've got that they will normally continue to be dealt with under the policy that was in place before the 9th of July 2012, page 271.
That was fine because he wasn't, you say, dealt normally with. So that first one doesn't help us, yeah.
And then normally they will be eligible to apply for settlement after accruing 6 years. And I
So
simply,
where are you now? I'm just not with you. Where on the page?
Sorry, it's page 271. Under applicants granted discretionary leave before 9th of July 2012.
Yeah.
And
First
the
normally
first
in the
paragraph,
first paragraph there, yeah.
those granted leave under the
Oh, I see
discretionary
the second one,
policy
yeah.
will normally continue to be done under that policy through to settlement if they continue to qualify. And then in brackets, normally they will be eligible to apply for settlement after accruing 6 years continuous discretionary unless the dated decision for restricted leave policy.
And this case, why did this case not apply? Why did this not apply to this case?
The restricted leave policies is specifically concerned with individuals in the refugee asylum cohort or in the humanitarian protection cohort. So it's common ground that that policy doesn't apply.
Okay. So right. So
that's the first norm.
he falls under this policy, does he? He yes. Okay.
So it's accepted that normally individuals whose applications were granted before the 9th of July will continue to be on a 6-year route to settlement rather than a 10-year route to settlement.
Right.
Then the next paragraph, and these are the 2 paragraphs that we looked at in some detail before.
So we deal with it, the circumstances are the same. The circumstances prevailing at the time of the original grant continue because they were primarily medical, the family, and the length of time, but those circumstances have not changed.
But there are 3 questions that looks to. If the circumstances remain the same,
Yeah.
except they do, the individual does not fall within the restricted leave policy, except he doesn't, and the criminality thresholds do not apply. So this takes us back to this question about
So it's
what are
absolutely critical
the
what that
criminality
means,
thresholds.
yes.
Undefined term.
And the term isn't defined in the policy, so far as I could see. But what we have in the policy by reference to what could fairly be described as thresholds of criminality in my submission are the thresholds in part in Rule 9.4.1. And then we have the reference to the exclusion and criminality section.
Well, this takes us back in circles then, because you haven't defined being out with the policy by reference to exclusion and criminality in paragraph 2. It's the criminality thresholds, and it's a continuation of the old policy. So whatever criminality thresholds were aimed at, they weren't aimed at previous offending.
Well, in my submission, that there isn't anything in the policy, there isn't anything in this policy that excludes consideration of criminality thresholds in relation to previous offending. And if you go back to what's said, the point I was trying to make, perhaps I didn't make it very well in relation to how the second and third paragraphs might be seen as being in a way the mirror image of one another, is that the first one is in a sense saying these are the circumstances in which you grant, where the circumstances are the same, where the criminality thresholds do not apply. The third paragraph, it's the converse of that, is telling you when not to grant. If there have been significant changes that mean they don't qualify, or they fall for refusal on the basis of criminality. And that reference to the exclusion and criminality hyperlink, which takes us back to page 254, that section on exclusion and criminality refers both to the restricted leave policy and to part 9. So that would create a symmetry between those two paragraphs.
If you're right, the consequence is this. Previously, historic offending would not have been something that barred the grant of further discretionary leave or ILR. Now, because of the changes in 2 and 3 read together, they will bar him. If so, why did the Secretary of State say in the opening words of paragraph 1 under applicant that the DL policy enforced before the 9th of July 2012 will normally continue? Because the reverse policy will continue. Prior to July, he wouldn't have been stopped because of historic offending. Post-July, or post this document, on your reading of it, he will be stopped. So the old policy isn't applied.
Well, my lord, that normally would still apply absent criminality, and that would still make a difference from the current policy, which has a general 10-year route to settlement rather than 6-year route to settlement. So it would still be a difference for individuals who are considered under the old policy where criminality doesn't apply.
Or another way to make sense of it is the old policy continued to apply. You'd expect significant changes to be red flagged. So you come to 2 and 3, and these words that are so clearly expressed could mean one of two things. It means actually historic offending is now something that has to be taken into account, or will normally be the end. But another interpretation is that no, they meant to preserve the position if there's new offending, and then the new offending will kick it out. One interpretation, the former one, is consistent with the old policy. The latter one is not consistent with the old policy. So should we favour an interpretation that's consistent with the opening words, i.e. the old policy?
Well, in my submission, my lord, it is still consistent when one has regard to the normal. It could be read normally, paragraphs 2 and 3 set out circumstances where that normally doesn't apply, which include the restricted leave policy apply and the criminality threshold apply. And that's not necessarily, of course, the end of the story, because, as in this case, the Secretary of State may still consider it appropriate to grant discretionary leave. But in my submission, that is a coherent reading of the policy, that also makes sense and gives effect to the references to the current paragraph 9.4.1 of the immigration rules.
So is it fair to say, the question is, did they intend to maintain the position for historic offending and clarify it for new offending? Is that what they intended to do? Or two, were they actually changing the policy so that in fact old offending would now bar grant of discretionary leave and possibly ILR? That's a fair way of describing the question.
My lord, I think that gets to the
Another bit.
another bit.
Did this applicant fall for refusal on the basis of criminality?
My lord, yes.
And is that what the Secretary of State did? Did she exercise her power under the third paragraph to refuse the leave application? Or was she exercising her discretion under the normally provision in the preceding paragraph?
Well, my lord, she was doing both. That is, she was refusing the indefinite leave to remain application by reference to criminality, and it may help if we go to the
Decision.
to go to the decision. She was refusing that application.
Is it 258, is it? Tab 20?
It's my lord. Yes, I think it appears twice in the core bundle. I've got it at page 115.
Let's go there.
The decision of the 23rd of September 2025. You will have seen, unless it will assist, I don't propose to take you through the history of previous decision making in detail, but I'm going to take you to one point on that. You will have seen that there were a series of decisions that were withdrawn that led up to
It seems to be roughly one line decision saying we grant you discretionary leave. I haven't seen any reasoning after the first tier tribunal decision, or have I missed something?
Well, my lord, in relation to the grant, the decisions to grant periods of discretionary leave, no. I think there are the previous refusal decisions which were subsequently withdrawn, but
Yes.
I don't propose to take you to those.
So there's just the grant after the FTT, which seems to be in one line, and then there's another one or possibly two, which are also one line.
In terms of the grants, yes,
Yeah.
that's right. And then the effective target by the time of the hearing of the claim was this decision of the 23rd of September 2025. So just looking at page 115 in the core bundle.
Tell me which internal page of the decision it is, because I've extracted the other version of the decision.
It's page 1, my lady.
Page one, thank you.
You'll see it says, thank you for your application for indefinite leave to remain. We've considered your application. You do not qualify for indefinite leave to remain. The reasons are set out in Annex A to the letter. But we are satisfied that you thought we granted limited leave to remain for 36 months out of the discretionary leave route. For reasonably valid issue such leave. These are reasons for this are set out in the letter. It then page 2 summarizes the immigration history. I don't use any particular points to take you to from that, but it gives you the chronology of the previous grants. Then at page 3, it considers a grant for indefinite leave to remain under the immigration rules on grounds of long residence. And at page 4, the internal page on page 118 of the core bundle. It refers to paragraph 9.4.1 of the immigration rules. Then at page 5, page 119 of the core bundle, it notes he was sentenced to 30 months imprisonment for supplying Class A drugs, and that his application falls for refusal by reference to that part. Then there's a consideration of whether the grant of leave to remain outside the rules generally, pages 5 to 6, of core bundle 119 to 120. And then the more pertinent passage for purposes of this claimant's appeal is the consideration under the discretionary leave policy, page 6. Page 6, core bundle, page 120. So it
Yes.
states your grant of discretionary leave prior to July 2012, which means you ought to be considered under transitional arrangements discretionary policy. Those arrangements can be found at page 31 of that policy. Then
Can I just put this next to the pages that they're talking about so I can see it? Because the letter summarises the first paragraph, does it?
It summarises the letter at the bottom of page internal 6. The paragraph, the last paragraph, quotes the first paragraph under applicants granted DL before 9 July 2012 on page 31, internal page 271 of the policy. It then runs into, at the top of page 7, the third paragraph. It omits the second paragraph.
Yes.
Agreed?
my lord, yes.
It then quotes from Mr. Justice Chamberlain, we haven't got on to that yet, judgment in Ellis,
Yes.
as to the meaning of the word normal.
Yes.
The normal that is in the passage quoted in the letter is in the first sentence at the bottom of page 120. That's where the word, those where the two normals appear, the first and third sentence.
That's right. Yes.
Yes.
Then you'll see it refers to page 8 of the discretionary leave guidance, and just to for following through in terms of where that is in the authorities bundle, that's page 248 in the authorities bundle. And this is where you have the sentence
Sorry, 288.
248. Sorry.
Sorry, forgive me.
And this is where you have the sentence under immigration rules. Part 9 of the immigration rules covers the general grounds of refusal and must be consulted and applied before discretionary leave is granted. And then it refers to the consideration of paragraph 4.1 which had taken place above.
And that reference granted sentence if there are any criminality or exclusion issues. What is that a reference to? 28 of the guidance that you just go through?
Well, that, my lord, is a reference to what's authorities bundle page 268. To the section on, to the general section on settlement applications.
Penultimate paragraph on page 268.
Yes.
And that's a reference to the criminality and exclusion section.
Yes, although it's fair to note that page, in fact, as it says at the top, is in relation to those cases where the initial period wasn't granted before 9th of July 2012.
Oh, I see. So the bit that she's quoted applies to a different cohort of people, the decision maker.
And page page 28 it does, but then page 31, which is the next reference,
Yeah.
is a reference
Constitutional.
to the transitional arrangements again, and it's to the
So
last
where does it come from?
It's the last page, authorities bundle, page 271, the last sentence of the fourth paragraph.
Of course, that doesn't really go to the heart of it, does it? The question is, do you consider it for new offending or old offending? That's the question in this case, isn't it?
My lord, yes, and the decision makers obviously have regard to the previous offending, and you'll see the paragraph immediately following that. The nature and seriousness of the past school offending been taken into account. It is acknowledged that there's been no further offending since the original conviction, which is a relevant factor in assessing whether the criminality constitutes a good reason to depart from the normal policy position. So it recognises the normal policy position, and that must be referring back to the normal policy position as summarised in the transitional arrangements.
So what was the normal position then? That past criminal offending wouldn't be. I mean, the nature of the I take it into account. They acknowledge there's been no further offending since the original conviction. It is a relevant factor in assessing whether criminality constitutes a good reason. So is that simply saying if there was fresh offending, that would have been a good reason? That's what it's saying?
Or it might have been a better reason.
It would kind of be yes, I suspect that would be a different and easier situation. But no, my lord, I think what that's saying is that they've had that in accepting, as they have by reference to the transitional arrangements, that the normal policy position is that there should be a grant of leave after 6 years continuous discretionary leave. That's the norm that the transitional arrangements recognise. And what the decision maker is saying is that the nature and seriousness of the past criminal offending have been taken into account. It's also acknowledging that the fact there's been no further offending is a relevant factor in assessing whether criminality is a good reason to depart from the normal policy position or not. And then in the next paragraph, it says, these aspects, including the decision analysis, are weighed carefully. Consider that the general grounds for refusal, the nature of your criminal conviction, supplying control class A drug, is considered sufficiently serious that it remains a good reason to depart from the normal position of granting indefinite leave to remain under the discretionary leave policy. Your criminal conviction for a prison sentence would result in mandatory refusal under Part 9 of the immigration rules. The length of your sentence reflects the seriousness of the offence and is a relevant consideration in deciding that there's good reason to depart from the normal position. So effectively, what the Secretary of State is doing in my submission, and this is how the recognition that it's the old policy that applies is squared with the with Part 9, is that rather than treating for the purposes of this application under the discretionary leave policy, Part 9 as being a mandatory reason and the starting point, it's saying the starting point would be the policy provides for grant of leave after the 6 years continuous discretionary leave, but the criminality is a reason for departing from that norm, having regard to its seriousness and such. And then they go on to consider the position of the child, and there's a more detailed consideration of that at pages 8 to 9, which I don't propose to take you to for the reasons I gave at the outset.
So it all boils down to whether or not we interpret that page 271 as saying historic offending isn't taken into account, only new offending, if the new offending would fall within Part 9, or whether the way it's worded brings about a situation where even historic offending can be a reason for departing. Is that what it comes down to?
My lord, yes. And that still preserves, as it were, a position whereby if there was no criminality, then normally you would still be benefiting from a 6-year rather than any different route to settlement. But the criminality is the reason for the departure from that norm. And that's tighter than it was under the old policy. But that, in my submission, reflects what those two paragraphs that we looked at in the transitional arrangements are seeking to achieve.
You say tighter, it's actually a change in policy.
Well, my lord, yes, it's describing the extent which
The state of affairs prior to the transitional arrangements was it wouldn't be taken into account. The state of affairs post the policy is it may be treated as a reason for not granting. So what you say as tighter is a change.
my lord, yes, it is a change, yes.
And it's a tighter change interpretation of the old policy, not just a new
Yeah.
change. That's the effect of it. The effect of the new policy is to tighten interpretation of the old policy.
Yes, the transitional arrangements don't simply, as it were, incorporate the old policy wholesale and say we will just be dealt with under that. Those further passages that we looked at would be unnecessary if the policy intended simply to apply the old. I mean, it could have simply said applications pre-July 20. Applications from persons who were originally granted discretionary leave before 9th of July 2012 will be dealt with under the old policy. Full stop. If it had simply been intended.
But they might have wanted to take account of two things. One, the circumstances might have changed, he's got better. Or two, there might have been new offending. And don't make any mistakes about treating new offending as something that qualifies.
They could tighten the consequences of new offending in a way which the old policy didn't provide for. They could make it more explicit.
Well, except, my lord, in my submission, the old policy already did both of those things. Because under the old policy, you would still look to see whether or not the person, when considering whether they qualified for a discretionary leave, you would still look to see whether the circumstances.
Yes, but did it say the further leave application should be refused, which under the transitional provisions, the third paragraph in the section we've been focusing on, was very specific. That is the effect of new offending under the transitional provisions. Isn't that a tightening up of the policy under the old provisions?
Oh, my lord, forgive me, we may be for purposes. Yes, I entirely accept that the transitional arrangements are a change as to the circumstances in which somebody.
There are fewer circumstances now in which you will get it as compared to before.
Yes.
Yeah.
And in this case, he would have got it before, but because of the change, he can't get it now. That's the legal consequences of the events that have occurred.
But it is quite a significant difference, isn't there, between saying, well, the consequences of new offending are tighter under the new policy, transitional provisions, on the one hand, but on your case, the consequences of old offending are greater under the transitional provisions. That's a significant conceptual difference between that, obviously, but one that isn't seemingly clear from the language.
Well, my lord, when one has regard to that reference under the relevant legislation to the fact that you must have regard to apply Part 9, and then you look at those two passages that we focused on, the transitional arrangements. In my submission, that is the effect. Criminality, whether it's new or old, has to be considered for the purposes of considering a grant under the discretionary leave policy. And that may constitute the reason for departing from the norm under that policy, that individuals would be entitled to settlement after a period of 6 years. That's the Secretary of State's case, and that's the issue the court needs to determine.
Because even under the old policy, it was clear that there was a ministerial discretion to refuse.
Yes.
And the new policy doesn't refer to any kind of ministerial discretion, presumably because they don't want to bother ministers with making decisions of that kind. So it's all dealt with under the terms of the policy by officials rather than by ministers.
My lady, yes.
I wonder why the decision maker didn't refer to the middle paragraph.
Yes. And
My lord, it isn't very clear because it's not clearly separated as two paragraphs. I can't I think go behind the the terms in which the decision is expressed. But I do submit that the nub of the decision makers clearly appreciated that the norm is the grant, and the consideration of the criminality has to be, are there reasons to depart from
Yes.
that?
But aren't we in the middle paragraph? Isn't that the key paragraph on your case? Of 2.7, the middle. Second of the three paragraphs we're focusing on, 2.7.1. Isn't it the second paragraph that applies?
Well,
And that's not, and isn't that also, we're going to come on to Mr. Justice Chamberlain in a minute, but I'm wondering whether that's the normally he's going to be referring to when we get to him.
well,
The normal is in that paragraph.
my lord, that may
Normally.
come, or to return to the submission I made before, that may come to this, the seeing those two paragraphs as being in a sense the mirror of one another. The one setting out positively, this is the exercise you look at in considering what leads to a grant. The second one, effectively doing the same exercise negatively, these are the circumstances in which there would be a refusal.
Well, can we look at paragraph 2? Because you may be wrong for another reason on paragraph 2. You must consider whether the circumstances prevailing at the time the original grant of leave continue at the date of the decision. That's fine, they do. If the circumstances remain the same, they do. The individual does not fall within the restricted leave policy. He doesn't. The criminality thresholds do not apply. If that means what's in the exclusion and issues, they do apply. And if they do apply, then you should refuse. You should only normally grant, but they don't apply.
Yeah.
So if you're right, you never get a 3, because if criminality thresholds mean if you've got a sentence of 12 months or more, then a period should normally be granted.
Yeah.
But he doesn't get to that because they don't apply, so he shouldn't get it.
It falls into paragraph 3.
My lord, yes. I mean, I think it's important to remember here. This is of course, this is guidance rather than a statute. It may well be that the subsequent paragraph is unnecessary and is intended just to clarify for decision makers, in a sense, the circumstances which, effectively, you're saying to decision makers in the second paragraph, this is what you look at to see tick 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 you grant. The second one of these, what you do refuse. But yes, I mean, if the criminality thresholds do apply, then that third aspect of the second paragraph isn't satisfied, and there shouldn't be a grant.
That's what I'm saying. So your submission, this is what I'm testing. You're saying one tells you when you should grant it and one is the reverse. But paragraph 2 on your analysis tells you you shouldn't grant in this case. You're not saying you should grant, but you're departing from it because it's not the normal circumstance. The situation is that if criminality thresholds mean the Part 9 thresholds, it shouldn't be granted.
Yeah.
Full stop. It's
Yeah.
a description of when it shouldn't be granted.
So, my lord, I probably didn't express myself very well. What I meant is it's effectively setting out the things you need to look at to consider whether to grant from the, as it were, from the positive side of it. Things are the same, don't fall in the restrictive leave policy, criminal thresholds don't apply, equals grant.
Then you grant. But the criminal
Second-
thresholds do apply here.
They do, so you don't
So you
grant.
shouldn't grant.
Yes. So, but what it's doing, it's setting out the, as it were, the checklist you go through to see whether you grant, and if, as in this case, you don't meet the third of those, you shouldn't grant.
Is that what the decision maker did here?
Well,
If we look at the reasoning, did the decision maker say you fall for refusal on the basis of criminality?
my lord, yes, and in my submission, that is what they say, and that's going back to page 121 of the core bundle.
Yeah.
Um,
Where do they say that?
where beginning the nature and seriousness of your past criminal offending have been taken into account. And you'll see that they're looking at that for the purpose of assessing whether or not there's a good reason to depart from the normal policy position.
They're not departing from the normal policy position on your analysis. The normal policy position on your analysis is because the criminality threshold are passed, because they mean 12 months or more, they shouldn't be granted. It's not saying they should be granted, but we're going to say no. They should have said, you don't qualify.
My lord, it is departing from the normal. If we take the normal policy position by reference to the passage they quoted from the transitional arrangements on the previous page, which is that normally you're eligible for settlement after 6 years continuous discretionary leave. So that's the normal. If there was no criminality, then the normal position would apply. You've been here for the 6 years, the circumstances are the same, you would get your grant of leave.
She doesn't need to have a good reason to depart from the policy, because if you're right in paragraph 2, the policy says you should be refused because the thresholds apply.
It has no discretion.
Yes.
My lord, yes, it's not a departure from the
It's the
policy
application of paragraph 2.
it's not a departure from the policy as expressed in the transitional arrangements,
Mhm.
but it is a departure from the normal position under the old policy. That's what I'm trying to say. Forgive me if I haven't been clear about
Well, I think, for my part, I'm concerned about the clarity in the decision letter rather than your submissions, Mr. Anderson, which are, as always, pellucid. I think I think that the decision maker purports to be exercising a discretion under the second paragraph of 471, the normally paragraph, whereas my lord said she didn't have that discretion because on your case, because it fell under the third paragraph, so leave should be refused without more.
I think, my lord, perhaps it's the difficulty that comes when we've got two different policies or normalies that might be being applied here. So, in my submission, what the decision maker is doing is recognising, as per the first paragraph of the transitional arrangements, that as a person granted discretionary leave before the 9th of July 2012, they're normally entitled to settlement after 6 years. So that's the starting point under the transitional arrangements. That would be what would happen, other things being equal, if there was no criminality. But the criminality explains why there's a departure from that norm. Now that isn't a departure from the transitional arrangements themselves, because the transitional arrangements tell you if there's criminality that meets the threshold.
It's words. It's not a departure from the policy. A departure from the policy means I am doing something that is not provided for by the policy. But here, in your analysis, she's doing exactly what is provided for by the policy. She isn't departing from it, reaching a result that is that which is not prescribed by the policy. On your analysis, she is refusing as she had to do because he had a sentence.
Yes.
And anyone else who's got a sentence has also got to be refused. And she can't say, I think this sentence is really bad, it's 4 years, that one's not so bad, it's 3.5. It is the criminality threshold, and if she's being loyal to the policy, she shouldn't refuse it. She would be departing from the policy if she said, notwithstanding the criminality thresholds, I've got a very good reason for letting him stay.
Yes, she's applying the policy as expressed under the transitional arrangements, and that involves departing from what was the old policy.
Well, does it follow then that anybody who's committed a serious offence at any point in history falls for refusal on the basis of criminality? Falls for refusal on the basis of criminality, so that their further leave application should be refused.
That, my lord, is the starting point, yes.
And that's quite a big change in the interpretation of the policy to such cases, isn't it? It's a difference between the old policy. The transitional provisions are quite a radical change, if that's right.
My lord, it is a big change from the old policy. Yes, but in my submission, that is what the transitional arrangements under the new policy
The
provided.
normally doesn't permit a departure. The normally prescribes refusal. What the departure would be if somebody could say, well, look, I know I've done this, but since then, I ran into a burning house and saved 2 children. I single-handedly leapt into a lake and saved another child. And surely there must come a time when I'm rehabilitated. That would be the departure.
It's not a departure, my lord, from the current policy. It's not a departure from the transitional arrangement, but it is a departure from
What
what
would have happened before? Because what would have happened before, he would have got it.
Yes.
Now he won't get it.
Yes.
So, although you're normally applying the policy before was you get it, the policy now is you don't get it.
My lord, yes, in my submission, that's the effect of the transitional arrangements.
I repeat, forgive me, the point I made. One would expect such a radical change to be clearly discernible from the document, wouldn't one? It's quite a big change. You've committed the offence 30 years ago, a serious offence 30 years ago. You've led a blameless life ever since. You've been granted discretionary leave on a number of occasions, and then, because of these retrospective change in policy, you're not anymore. And because the leave application should be refused on this interpretation. That's quite a big change. One would expect it to be clear from the document.
I would certainly accept, my lord, that it's a big change. I don't accept, my lord, that it's retrospective as such, because applications are always, starting point applications are always
Okay,
done.
well, maybe that's loose language.
That's a separate issue, yeah.
Forget that
I
point.
wouldn't-
A change in treatment, never forget retrospective, quite a radical change in treatment of such people, one would expect it to be quite clearly telegraphed.
My lord, I accept that it could be clearer, but in my submission it is sufficiently clear.
That's the question. It seems to me the question is, what does it mean? I mean, the Secretary of State has chosen this policy, and that was her choice, and it's up to her, and we've got to try and interpret it. I can well see lots of people who would say you should never get settlement if you've committed drug crimes or if you've committed this crimes. Different people would say different views. Some people would say he was young, he was 19, he's learned his lesson. Other people would say that's fine, but you don't get settlement in this country if you've done it. I see all the policy arguments either way. Unfortunately, because we're only judges, we don't have to grapple with that. All we have to grapple with is what was she doing when she wrote these words on the page? And if she decided in the past, if I've given you a deal, the discretionary leave and nothing has changed and there's no new offending, we'll carry on, that's her choice. And she can answer to Parliament and the electorate. If she wants to change it, she probably can change it. But then she's got to say what she's doing. Isn't that where we are?
My lord, yes.
Yeah,
And my
that's it.
submission is effectively that is what the Secretary of State has sought to do.
I've done here, yes.
Can I, and I know we've probably squeezed this lemon dry, forgive us, Mr. Anderson, but this is an important point. And for my part, I want to make sure we've really tackled it before we move on. It could be argued, and this goes back to a point I made a long time ago this morning, it could be argued that the way the two paragraphs are structured is indicated by the initial words. So the initial words in the second paragraph are, well, the two paragraphs, you must consider whether the circumstances prevailing at the time of the original grant continue the day of the decision, right? Second paragraph, if they remain the same, then that applies. Next paragraph, if there have been significant changes, that mean. So in other words, as I suggested to you earlier, the phrase "the applicant falls for refusal of basic criminality" as a result of the is following a significant change. So it only looks at subsequent criminality. Is that on one view the more straightforward interpretation of these two paragraphs?
My lord, in my submission, whilst I can see that as a possible reading, I would urge the court not to adopt that reading. In my submission, the better way to look at it is to see those paragraphs as being, as I tried to submit in a sense, the mirror of one another. If there are changes, no restricted leave, no criminality grant. if there haven't been changes, no restricted leave, no criminality thresholds grant. That's paragraph 2. Paragraph 3, if there have been changes or exclusion in criminality applies, don't grant. And that exclusion in criminality incorporates both the restricted leave policy and the criminality thresholds, which I took you to earlier. So that, my submission, is how those passages are best read together. Having regard to the fact that, as we saw under the section on relevant legislation, it stated that Part 9 of the immigration rules must be consulted and applied before discretionary leave is granted. And so what we've got to do is accommodate a way in which that's still pertinent to the decision.
Yeah.
To the decision. Those are my submissions.
Yeah, and I think you would also want to add, presumably, as supporting your submissions, since we've given you 101 reasons why they may not be wrong, out of fairness, let's give you one that's right. At the end of the day, if my obsession with paragraph 2 were correct, and that's what dictates the outcome, I've still got to give some meaning to the words criminality threshold. What's that mean, and what is it there for? It is clearly there to knock out something to do with people committing crimes, and the question is what?
Well, we've probably looked at this, I won't say ad nauseam, but we've certainly covered it very thoroughly, and you'll be very patient with us for intervening. Where do you want to take us to now?
Well, my lord, I think perhaps just a few things, if I may. So I think we should probably briefly look at the medical leave policy, because that's the other policy that was in play in this case. I took you earlier to the link passage, as it were, between the two of them. We've got this policy at tab 17 of the authority bundle.
Yes.
I think the relevant passage is at page 358. Under the heading well, perhaps just for completeness, go back to page 357 first of all, which is headed granting further periods of limited leave or indefinite leave. You'll see that the first paragraph indicating that given the high threshold and nature of cases granted leave on the basis of a medical condition, should only be in exceptional cases that a period of limited leave is required. It then provides further periods of limited leave effectively needed to be considered in light of the circumstances as they are at the time of the application. And then under granting settlement, 358, if you're considering granting immediate settlement in cases where the claimant has not previously been granted leave on the basis of a medical condition, you must refer to the discretionary guidance on granting longer periods of leave. If following a period of limited leave to remain claimed applies for settlement, it says that application must be considered in line with the immigration rules. Some people may be excluded from applying for settlement due to various issues, including criminal record. And it then says, however, when a claimant has held discretionary leave for 10 years, brackets or 6 years under the transitional provisions of the discretionary leave policy, and continues to qualify on the same basis as the last grant of discretionary leave, you would generally grant indefinite leave to remain unless there's a compelling reason not to do so. You must refer to the guidance on discretionary leave for consideration of indefinite leave to remain applications. So, in my submission, this, with its various cross-references to the discretionary leave policy, doesn't really take matters any further. And effectively, my submissions are that the criminality is what would be considered to be the compelling reason not to grant indefinite leave to remain under that policy. And that was the approach that the decision maker took, which you've got at page 122 of the core bundle, where they consider the medical leave policy, they basically quote the whole of the granting settlement passage,
Yes.
and then says these provisions expressly refer back to the discretionary leave policy. The assessment of eligibility for settlement rate governed by the criteria and principles under that policy, and hold that it doesn't
Yes.
change the position.
Thank you.
So that is what I wanted to say about the suite of policies.
Yes.
for you.
Thank you.
I wanted very briefly to touch on Ellis.
Yes.
It's obviously not binding on us report, but both parties relied on it below. You got it in the authorities bundle at tab 9.
Do we need to worry about the facts?
My lord, I don't think so. Save to note that, or save to note 2 points. This was prior to Part 9 of the immigration rules having been introduced, although there were different provisions providing that criminality was an obstacle to the grant of leave to remain in certain circumstances. And this was a second offending case, that is, there was a subsequent offending case. That is, the individual had been convicted of an offence after the
Yes.
initial grant of discretionary leave. The relevant passages, I think, really are.
And in terms of the policy it was looking at,
The policy was in very similar terms. It didn't, as I say, though, make reference to Part 9 of the
No.
immigration rules.
it had
because
paragraph numbers too, didn't it?
that,
Policy. Have I got that? Or I misread that. I was trying to work out
yes.
exactly how it fitted, and I couldn't immediately, I'm afraid, tie it in. So the relevant parts of the post are quoted paragraphs 15 onwards. And am I barking up the wrong tree? Do say so, Mr. Anderson, if I am.
No, my lord. I think it was version 7 of the discretionary leave policy.
So starting at paragraph 17, for example, there's a quotation from the policy with paragraph numbers with 1.2.
Yes,
So it's a different version of the policy.
yes, this was version 7 of the policy.
Okay.
Whereas we've been looking at version 11.
Yes. And yes, and the key period, the key passage is paragraph. What is where? The policy, the policy he, Mr. Justice Chamberlain, was looking at. Where is that set out?
So at paragraph 23,
Yes.
page 127,
Yes.
that's where you've got the
Equivalent.
equivalent transitional arrangements policy.
Yes.
So
If we just had our finger in that and then went back to page 271. We would see that the first paragraph of paragraph 23 of the judgment is in similar but not identical terms to the first paragraph on 271.
yes,
This may explain or help explain the meaning of criminal thresholds, because there wasn't, or was there, a heading exclusions and criminality? So it must have been a shorthand reference to the paragraph in the rules, or can you not work out from policy version 7 what criminal thresholds meant in policy version 7? Because it looks as if that was probably just carried.
Would it be helpful to have over the short adjournment a copy of version 7?
I will certainly see if we can get one.
So for my part, it would be helpful so I can understand exactly how Mr. Justice Chamberlain's analysis fits into this
Can you
case.
see what I'm driving at with the definition?
I do, my lord,
Yeah.
yes, thank you.
But I noticed that the going to 23, of Mr. Justice Chamberlain's judgment. The second paragraph quoted from paragraph 10.1 of version 7 that again is similar to the second. It's a version of the second paragraph, isn't it?
Yes.
It would be worth seeing more.
Maybe again.
Maybe right. It's just But there's nothing in this judgment equivalent to the third paragraph of 271, is there? Or if there is, it's not there.
My lord, no, I don't believe so. So I'll sort of see if we can check whether there's anything
All right.
in the policy.
Maybe this is a red herring, but I think it would be good to have version 7 if we could get it. So do you want us to go to paragraph 39 of the judgment?
My lord, yes. It's page 132. I should perhaps just briefly note it was common ground that the approach the judge took in paragraph 35 of his decision with regards to the fact that the meaning of the policy is a matter for the court to interpret objectively. Is common ground below in this case and remains common ground for your lordships. Paragraph 39 onwards, in particular paragraph 40, in a normal case, an individual granted their 3 years discretionary leave will be granted a further 3 years discretionary leave.
He can only be saying what he's saying in paragraph 39 and 40, the judge, if he's decided the criminality thresholds do not apply. He wouldn't be into normally otherwise, would he?
Well, he would, my lord, still be in the threshold of or in the territory of normally, because the discretionary leave policy, the old policy, provided that you'll normally be granted.
Look at 23
after-
again of his second paragraph of the quotation. If the circumstances remain the same, the individual does not fall within the restricted leave policy and the criminality thresholds do not apply, a further period of 3 years should normally be granted. But that must mean that if the criminality thresholds do apply, then it will not be granted. So he must have assumed that the criminality thresholds didn't apply, or he wouldn't have gone on to the would normally be granted.
My lord, in my submission, that's not quite the case, and that's because the normally, I think that he's referring to then, is the normally in the first paragraph, quoted in paragraph 23. That is the fact that you will normally qualify for further leave. After 6 years continuous discretionary leave. I think that's the normally that he's referring to. The second paragraph quoted in paragraph 23 includes within it certain circumstances in which that norm doesn't apply, i.e. the criminality thresholds. So my submission that the normally he's referring to there is that first normally that under the discretionary leave policy you qualify after 7 years. Then at paragraph 41, he notes that caseworkers should consider whether there are circumstances that warrant a departure from the norm. The policy doesn't specify what might justify such a departure, but a criminal conviction since the last occasion could in principle plainly do so. Now I pause to note there that the fact that he refers there to the fact that a new criminal conviction could plainly do so doesn't, in my submission, equate to him saying it has to be new offending. As my lady Justice Laing expressed it, it may be a better or more obvious reason if there's been subsequent offending, but that doesn't mean that previous offending couldn't still.
I'm wondering if version 7 did include the third paragraph on 271.
So we'll certainly hopefully see if we can dig that out.
Because if it did, it's not immediately clear to me why Mr. Justice Chamberlain drafted the judgment in this way, because he wouldn't need to go on, would he? If there was a paragraph equivalent to the third paragraph on 271.
Looking at 23 and 39 to 42, it can only make sense if he decided that the criminality thresholds didn't apply, and therefore he would normally be granted, and he was looking for a reason why it shouldn't be granted, and the only reason that he identifies as being a reason why it shouldn't normally be granted is the new offence, which again makes me think that there's an assumption that the old offending didn't knock him out because of criminality thresholds. It doesn't make sense otherwise. Do you see my problem? Not really.
My lord, I do in terms of the way that it's expressed there. I simply make the point that in terms of the point that paragraph is making is simply that subsequent offending could in principle amount to a departure from the norm that's previously been expressed, which is that you continue to benefit under the old policy.
That you continue, because the criminal thresholds don't apply, to get the grant. That can be knocked out if there's a new offence.
But the first two are simply, in my submission, are simply referring to the norm that after the 6 years you get your grant of leave.
I see that because it talks about eligible to apply and so on. But it's the rest of it that follows. It's not expressed, but he wouldn't have got into normally depart if he thought the criminal thresholds were otherwise met. Yeah. You follow me?
My lord, it may not be necessary to, but I simply say that one can't, in terms of what he's expressed.
We shouldn't need to it because he's not looking at it the way that we're looking at it here.
Could we, it's a time out of you, Mr. Anderson, I just wonder whether we might be better pausing our look at Ellis until we get version 7. I'm conscious of the time.
Yes.
It's because this is not, in my view, a straightforward issue. We've taken a lot of time and interrupted you a lot, for which I apologise. But would it be too much to suggest that we park Ellis for 10 minutes and you go on to what you're going to say next and then come back to it when we've got version 7? Is that going to cause you difficulty?
My lord, no, that's entirely fine as far as I'm concerned. The only brief point I was going to pick up from Ellis was just that next paragraph where the judge refers to the fact that normally, I think he puts it in terms of it's been used advisedly to preserve the Secretary of State's discretion.
Absolutely.
And rely upon that with regards to the reference to normally in the policy. Otherwise, my lord, I think we can move on from Ellis to the and since we've already looked at the decision, I think we can look on to the judgment itself. The core bundle at tab 12 from page 94 onwards. I take no issue with the summary of the facts or the procedure or the key passages in the policy that have been quoted by the judge. I actually look into some additional passages, but we can, I think, begin looking at this from page 102. There's a comparative analysis of Ellis and TT. I don't propose to take you to TT because the issue in that case was a bit different. But in paragraph 42, where the judge is considering Ellis, you'll see a couple of lines down. Ellis is not authority for the proposition that any historic conviction justify departure, nor that offending known at the time of previous discretionary leave grants cannot amount to a good reason to depart from the norm. And I posted in my submission that's right. Ellis isn't an authority that was dealing with that specific question. Then in the last sentence, the judge says that it doesn't foreclose the possibility that in an appropriate case, historic criminality might be treated as sufficiently serious to justify departure, provided the decision maker engages with DL policy and gives a reasoned explanation for considering the case abnormal. Well, I take no issue with that. And then the last sentence, for example, new information could come to light about a known conviction. That would simply be one example, but in my submission, it's only an example, and it's not something that's necessary. Neither the policy nor Ellis says that there has to be something new. Then at paragraph 44, I think it's important just briefly to note about 5 or 6 lines down. So second, TT proceeded on an entirely different basis, treating paragraph 9.41 of the immigration rules as applicable, requiring the claimant to show exceptional circumstances. That approach is inconsistent with the concession made by the defendant in the order of the 1st of July 2025. Paragraph 9.4.1 does not apply to transitional DL cases. I just pause there. In my submission, that is with respect to an error on the part of the judge. If I can just take you to the order of the 1st of July 2025, which is in the supplementary bundle. It's at page 5
Yeah.
of that bundle. And you'll see in the third recital to that order, it says, upon the defendant confirming the claimant's application falls to be considered under her policy on medical claims and under the transitional provisions of a discretionary leave policy, the first which was set up was Justice Chamberlain, Ellis, and B, Part 9 of the immigration rules is not therefore determinative of the claimant's application without consideration of the individual circumstances of his case. And the short point I make, my lord, is that Secretary of State did not, in that recital, concede that 9.4.1 doesn't apply, simply that it's not determinative without considering the individual circumstances of the case. My lord, although I'm conscious there's a few minutes before 1 o'clock, I wonder if that
Would that be a good point to stop?
juncture, simply in terms of moving on to the next.
Yes, well, we've interrupted you, and you're perfectly entitled to say you want time to regroup. Very helpful, Mr. Anderson, as always. Should we come back at 5 to 2? Right. Look forward to seeing you all there.
Jack, sorry, do you have version 7? Because we do. You've got it. Okay, fine. Just thought it might help.
Appreciate it.
Procedure. I think it's quite bizarre procedures. It says that, you know, you can say anything at all and then revisit it all again. Whereas if you can kind of have a proper discussion and then you can. Yeah, no, it's a bizarre procedure, I think, because he can just say, actually, it doesn't mean anything. If you come in and question, they should then ask you as well. So otherwise, you've got to go back over it. So you can completely mislead them by not seeing something in the policy.
I will have to go back over some of it.
Yeah,
He said he was going to be very hard time.
I know, but I'm just saying that the procedure is, because if he's asked for something, then it would be easier. Well, let's deal with it point by point, and then you deal with this. Let's see what to do. And you, but
I'll take instructions.
I just think it would work so much better that way. I would say. Waste of time.
Sorry, I'm gonna lock the doors for lunch. Sorry, I'm heading out.